Okay, welcome everybody. We're going to talk about fraud today. Presentation is for instructional purposes only. I'm not your attorney. Turn off your AI note takers. They cannot be turned on. I do not want this recorded. This is for CLE credit, 1 hour of credit. Everybody remembers to put this in your professional development tracker, et cetera, et cetera, et cetera. After the presentation, we're required to submit to the CLE Accreditation Board your reviews of this presentation, so please do that. Okay. We're talking about fraud and concealment, and if you work at LOIS Law Firm, you have definitely raised fraud more than once, probably many, many times. And you know this is something, when we raise fraud, everyone in the whole hearing goes, ugh, and the judge makes a face at you, and they go, oh, well, they're doing it again. But this is an important part of what we do here, okay? Our job is to protect employers from being preyed upon. Raising fraud is one of the most important things we can do as their advocates. Remember, they don't have any other voice except for us. And our job is to keep them from being taken advantage of in workers' comp court. So this is an important opportunity for us to do that and be advocates. Remember, there was no such thing as workers' compensation fraud until 1996. That was when the fraud statute was added to the workers' compensation law. That's why every case you're going to see me cite and everything that we're talking about, every case law decision comes from after about the year 2000, because before 1996, the statute wasn't on the books that allowed us to raise fraud. All right, what we're going to talk about today. I'm going to very quickly go through like the first half of this presentation, because again, if you work here, you've seen it before, you know this stuff, it's been drilled into you. And I want to talk about a couple new things. I want to talk about some of the new case law decisions that have come out, and I want to talk about the protocol that we recommend to our clients when they are going to do covert surveillance. And I want to talk a little bit at the end about unmanned surveillance, about a case we're currently defending, that I'm defending, that involves unmanned surveillance and how we're going to utilize unmanned covert surveillance in our cases going forward. Okay, so that's what my goal is. I also want to remind clients who are listening, because we do have clients joining us today, how do we raise fraud in a workers' comp case? Well, we have to do it on an RFA-2 form. It's now an E form. There's a little button you click on there when you're submitting this. Clients, you need to add us as a party of interest so that we can submit this RFA-2 on your behalf. Who here has so far, I mean, they broke it after they dropped it last month, right? March 20th, they dropped it. And then by the end of the day, they said, oh, this E-form doesn't work. Last week, they promised us it does work. Has anyone used the new E-form yet? Okay, we've got Emily, good. Congratulations, you're the one, okay, so far. You've tried to and it didn't work. Okay, so the board's clearly having some problems with this. But this is how we're supposed to raise fraud in our cases. So what's the definition of fraud? It's lying about anything to get benefits, although as I'll explain in a minute, they don't actually have to even get benefits for us to raise fraud. Your case doesn't even have to be established yet. I know that there's some contrary case law, and some judges will say, case hasn't been established, you're raising fraud before I've even established ordinary benefits are flowing. The most recent case law, and what I cited in the Monday message, and if you're a client, I cited in my Tuesday tip, is actually, there's appellate level direction that says we can raise fraud even before the case is established. Okay, so it's lying or it's concealing. The claimant doesn't actually have to get any benefits to commit fraud, right? Many times they don't actually get any benefits yet when they've already committed the fraud, so we can then raise it. There doesn't have to be any present award for benefits in order for the judge to find that they have violated Section 114A. Now, if you raise this and the judge says to you in the proceeding, like, hey, Greg, I haven't actually, no benefits are flowing, the case isn't established, this is the moment to raise your objection. One of the cases that I put in the Monday message or the Tuesday tip, if you're a client, is a case where they didn't make the objection and tried to raise it later and then were foreclosed from it. You make the objection, you can also try to stay benefits going all the way back from the time you first raised fraud, not the time they were first entitled. So be mindful of that. That's an opportunity for us. All right, the definition of fraud is any misrepresentation. What's a misrepresentation? I'm not telling the truth about what my condition is. Another thing I want us to be thoughtful about is the misrepresentation is not what we capture them doing on our covert video or what we capture in our social media. The misrepresentation is what they told the doctor, right? That's what we're actually going to be able to parlay or rely on for us to establish fraud. The misrepresentation is what they're reporting to the physician, not what we capture on the video. So that's important. And that the reason I'm talking about that as an anchor is you get great video. Your first thought should be, well, when was this video obtained of this claimant? And can I go and compare that to a medical record so that I can demonstrate that that was the misrepresentation? Again, their activities on the video, that's not fraud. It's when they misrepresented their abilities, their activities of daily living, or their condition to their physician. That's the actual moment of fraud. And then concealment, which is probably one of the more common types of fraud we deal with. It's just misrepresenting their abilities or just not telling someone about that. Okay, it's powerful because the duty's on the claimant to be truthful. And again, it doesn't have to be a money benefit that they're obtaining. It's strategic and it's tactical. Now, it's strategic because if you win on fraud, you might be able to foreclose their entitlement, right, the lifetime ban, to future indemnity benefits in the future. My observation is once you do that, the medical is probably going to come to an end and your case is going to be very amenable to either settlement or being closed at that point. I mean, you've essentially won. It's also tactical. Maybe it doesn't win your case for you, but it gives you an opportunity to create some leverage and get that Section 32 settlement that we're trying to steer this case towards. Even in a case where you have a strong fraud argument, I'm so happy to still settle that case under Section 32. Why? A Section 32 can't be appealed. So again, you'll never see me saying, well, you've got a strong fraud argument. Don't settle the case for $5,000 or $2,500 or wherever you think nuisance value is in your particular case, because that might be actually better for you than winning the trial on fraud and having them have the opportunity under Section 23 or Section 123 to either reopen that case or to appeal it, and then we've got to defend an appeal. So just be thoughtful. Even when you raise fraud and you've got a great case, it's still an opportunity for Section 32. It's also a great opportunity to bluff, right? So you don't have the greatest fraud. And this is one of the things I think we coach people a lot in office hours. Well, I got this video. It's not so wonderful, Greg. It's not like a slam dunk. I'm like, just go for it. Just try it now. Because what happens if you lose and the judge says, well, I don't think this amounts to a fraud. We're going to allow benefits to continue. You can do it again and again and again, right? This is not one of those issues that's going to be re judicata and foreclose you from raising fraud over and over again as the case progresses or develops. So raise it early, raise it often. I think, again, for the opportunity there on a tactical basis to maybe bluff your way or pressure or leverage your way into a settlement, that's a very acceptable use of fraud. All right, some red flags. I think we all know these in our cases. We see those professional plaintiffs, the claimant who's got 9 prior workers' comp cases. You know, they've been around the system enough. The number one predictor that you're going to have a workers' compensation case in the state of New York is you've had a prior workers' compensation claim, right? Once you've been through the system, you understand how it works. Next thing, law firm, note who's your adversary. Are they the kinds of questionable lawyers who advertise on bus stop benches and on daytime TV? Are they ginning up a lot of these cases? Who's the doctor? You know, start to make those inferences. I always think in my cases, when I look at missed medical appointments, like why are they missing medical appointments? Sometimes you look in those PT records and they're spotty. Oh, they went on vacation or they couldn't be here because their kid was sick. I'm looking at all of those reasons because they're trying to delay and elongate their case. Another thing to look at is impossible financial situations. Impossible financial situations. Zaraya Wade and I were on a call with a client and we're looking at this case and we're like, how is this person sustaining their life? They're getting a weekly benefit, which at the state minimum rate, they've been on temp now for like 3 years. This is so strange. Zaraya's like, they've got to be doing something on the side. And she said actually to the client, maybe they have an OnlyFans or something. Like, how are they staying alive on $150 a week? Like, it's not possible, right? So I want you to be thoughtful. If someone's been on temp for years, how are they staying in their apartment? Like, how does this work? Those things should be our red flags because they don't seem possible to us. There's a lot of medical fraud. There's a lot of corrupt and crooked doctors in our system. We've seen them before. Lots of red flags there. If you see a Surgicorp case or you see a Marola case, even though I think that he's backing away from workers' compensation very quickly and attempting to recharacterize himself now as an IME physician, what? We're never going to use him, right, guys? No. You know, be thoughtful. Like, are these the red flags that we see? How about lots of repeat surgeries with no improvement, long treatment courses with absolutely no improvement? How about the medical records where every single appointment looks exactly the same, like it's a canned report, it's a copy and paste report? These are the things that should be initiating those red flags in our minds, and we should be looking at those kinds of cases. All right, the burden's on us once we raise fraud. We have the burden to show by way of substantial evidence that the claimant knowingly made a false statement in order to obtain workers' comp benefits. Okay, that sounds like a high burden or a high threshold. It's not. Substantial just means anything, and willing or knowing misstatement is anything they say that we think is not true. So these are actually a pretty low threshold or burden for us to meet. Again, this is why I don't have a problem with us raising fraud, even when we observe the covert video and we go, well, it's just them doing their shopping or driving their kids around. I'm like, raise it, see what happens. You never know. Okay. Now, the only benefit that's affected by a fraud finding is money. So even when we do prevail, and let's say we prevail at the highest level and we get a lifetime ban, which we know the board does not like to sustain a lifetime ban, we get a lifetime ban. The only thing that gets affected is money. They still have the right to medical treatment. Are they still going to get medical treatment once their money is cut off for going to more and more nonsense doctor appointments? The answer is no, right? So you've really moved your case forward towards closure. All right. There's different types of proofs that we're going to introduce in these cases. And I'm going to break them down into basically two big buckets. One is covert and one is non-covert. Surveillance covert observations are those where we've hired an investigator, we've hired a company, and they've gone after this claimant and they followed him around or they did some sort of investigation. We'll call those covert. The other ones are just general observations or published or known facts, like general business records, right? It's not covert if you find out that there's a Gold's Gym in their town and you obtain all of their punch in, punch outs at the Gold Gym. That's not covert at all. And there's going to be different standards for how we're going to introduce that. And I really want to talk about the sequencing of that today. ISO reports, not covert. Social media posts, not covert. Any licenses, government records, anything they say about themselves. Again, those are non-covert proofs. They've got a whole different standard for how we're going to introduce those into evidence and how we're going to rely on them. When you're thinking about raising fraud, one of the biggest questions you should have in your mind as you're preparing your case is, how am I going to get this information in front of the judge? And I want you to think about the sequencing when. And there's going to be different sequencing for covert and non-covert, and what the judge can force us to turn over. So let's talk about that because I think that's important. All right, obvious examples: working on temporary total disability, passive income counts, volunteer business work counts, unpaid work on their own new business they're going to start, that all counts. Making up the accident, right? Staging the accident, those are obvious frauds. Failing to disclose prior injuries, that's an obvious concealment. Even when it's not work related, even if it's in a high school football injury, they have a duty to reveal all those things. Misrepresenting their activities of daily living, I think is probably the most common one. They tell the doctor, all I do is sit in a chair all day and watch TV. I'm in so much pain. All I do is take my meds. Like, those are the most common ones, I would say. Criminal activity resulting in income. So you find out that the person, while they're collecting temp total or temp partial, is convicted of some kind of crime. That's an automatic raise fraud because that crime was in furtherance of something, some material benefit that they were trying to obtain. So be mindful of that. Another example of fraud is the claimant who comes out of the doctor's office, takes their cane, throws it in the trunk of their car. I know these are uncommon, but I mean, we see one of those. That's wonderful and a great opportunity for us. All right, let's get into non-covert evidence first. And I want to talk about specifically how we introduce this in court, how we can rely on, what the judge can force us to turn over, and when, right? Because when you raise fraud in New York, how many adversaries do you have in the courtroom? Well, you've got opposing counsel, right, who's going to make all of their arguments, and they're going to say, well, nobody said this person's temp total. Doesn't mean you can't do anything. And you're also going to have the judge who's going to look for every potential reason not to allow you to put your case on the record. Fair? Okay, that's just a, yeah, and that's a kind of rhetoric question, but we're all commiserating here, right? We're all doing the same things. Okay, all right. So let's talk first about non-social media. Business record, you've got a lot of opportunity to introduce this stuff. There's a lot of reasons that this can come in without specific authentication, right? You're going to put covert surveillance in, you're going to need someone to authenticate that covert surveillance. But there are many records that can come in, which would come in as either a business record exception, which means you do not need to produce a witness to authenticate them, right? Medical records, of course, always get a presumption under Section 21. Medical records are deemed not hearsay and containing the truth of the matter asserted in the medical record, right? That's the definition of allowing it in over a hearsay objection. The court can also take judicial knowledge of published information in matters of common knowledge. The most famous example of this is the claimant Dubrel. The case is called Dubrel versus Maplecrest. Dubrel claimed that he couldn't do any work. Yes, I used to own horses. I don't own them anymore. Adjuster in that case happened to be a fan of horse racing and said, well, he has horses. Let's go through all the horse racing magazines, the ones that publish the odds on horse racing. And they determined that this claimant actually was engaged in harness racing while allegedly temporarily totally disabled. Nobody caught them harness racing. Nobody caught them on video raising horses or training horses, but there were published results in the horse racing magazines of the horses' results and the winnings that they obtained. You don't have to authenticate that. You can say, Judge, this is published in a magazine of general circulation. You can take judicial notice that that's a true fact or that's a published fact, and that can come into the record. And there's interesting case law all around this on judicial notice, even things like entries into the IMDb or any websites you find. You can make an argument that the judge is allowed to take judicial notice of those, okay? Again, our job as the legal team is to figure out how this record is going to come in. How am I going to move it into evidence so that the judge can rely on it, and so that we can then establish that the claimant's statements or concealments are material to the case. You should also be thinking about the timing of this, right? So if you have non-social media evidence that you want to bring into your case, okay, something like an ISO, you should be thinking to yourself, do I want to use this on rebuttal and confront the claimant with this on a surprise basis? Or if it's an ISO, I could also use that ISO in furtherance of my RFA-2 request for further action to get the case to list the case for a hearing on the issue of fraud. Of course, if you do that, you've lost the surprise value of what's in that ISO, right? And maybe you don't care because maybe that ISO is so compelling, or that horse racing result is so compelling. You're saying to yourself, I don't even need to confront them with it on a surprise basis. I'll move it into my case in chief, and I'll keep my powder dry, and I'll do other things on my rebuttal. Okay, so that's how I want you to sort of think about, how you're going to introduce this evidence and when you're going to use it. Now, a lot of judges are going to say, well, you've raised fraud. What's the proffer, right? What's the basis for it? And what are they going to threaten you with? A frivolous controversy penalty if you don't give them some answer, right? So again, be thoughtful about the timing and what you're going to bring in. Now, social media information is always admissible, and they're going to make a hearsay exception or a privileged exception or say it's private. There is case law in this jurisdiction from 2023 that says, quote, the nature of Facebook and Instagram is that communication of information is initiated by the user, in this instance, the claimant. Generally, its purpose is to broadcast to as wide a network of contacts as possible to pass on information that the user wants to have disseminated. The claimant cannot assert that she put out a very public advertisement for everyone to view, except the carrier and its investigators. All right, so I think you should have a very easy time. You can rely on this one to introduce social media against any kind of objection that you have. Again, if you're going to use it as your case in chief, as the basis for raising fraud, you're going to have to reveal it. And the judge will be allowed to order you or direct you to turn it over before the claimant testifies. So if you can raise fraud and then not turn it over and then use it on rebuttal, that's great. You might be able to keep it in your back pocket. But again, be thinking about the timing of when you deploy it. Now, social media investigation is fertile ground. We all know this. But let me just start off with my first statement. We do not do social media investigations. Okay, we are defense counsel and paraprofessionals, and we are not witnesses in our cases, so we're not doing it. Unlike with video surveillance, it doesn't need to be disclosed prior to developing the record on the issue. If we have this information, let's say you get this information from your client, like, oh, we know about social media, please don't go looking for it yourself. Even if you find great stuff, direct the investigator to go collect that and then provide it to us. Again, we do not want to become witnesses in our own cases. So I'll repeat it again. At LOIS, we do not conduct social media investigations. Just all nod because you know this, right? Okay, good. All right. All right. So think about the admissibility of non-covert evidence. If you're using it for the grounds for raising fraud, you could be directed by the judge to turn it over before the claimant testifies. Okay. But if you don't, if you can raise fraud for any other reason besides what's in that document itself, You can keep it in your back pocket and then use it at rebuttal. So really how you're going to use this information is very important. I also think the interesting case would be you have great surveillance of the claimant. You rely on the surveillance to raise fraud. Okay, that's the basis for your RFA2. We have covert information. The judge says, why am I setting this case down for a hearing on fraud? You say, I have great covert surveillance, judge. I need to take their testimony. You also, let's say, have a wonderful ISO. You also have maybe wonderful business records about them punching in and out of the Gold's Gym. You also have their social media posts, which you think are all going to be material to the issue of fraud or concealment. You've raised fraud based on the video. You can keep all the other stuff in your back pocket and use it on your cross-examination or rebuttal. And at that point, you're not going to have to turn it over in advance. Okay, so it's very important for us to think about what evidence we're going to develop or we're going to introduce and when. Okay, so if it's part of your case in chief, unless it's covert, the judge is going to be allowed to ask you to turn it over first. So again, if you have more than one type of evidence that you think is going to help you establish your fraud or demonstrate concealment, be thinking about what part of the case you want to introduce it. You could take something in which ordinarily you'd have to turn over before the claimant testifies, an ISO, a business record, social media, and maybe keep it in your back pocket. And that's you using the timing of that disclosure effectively to maybe have a better cross-examination of the claim, okay? If you have a case that has all these different types of evidence that you might want to develop, I think I would recommend strongly to think about that sequencing and bring that to an office hour. So we could talk about what's the best sequence for introducing it. All right, so example one, let's say you're using an ISO report as the basis for raising fraud. And why is it the basis for your raising fraud? Well, the claimant said on their employee claim form, I never had any priors. I never had any prior injuries. Well, you've got an ISO that reveals multiple priors. If you file the RFA2 raising fraud based on that, and you say it's because I have an ISO report, you're going to most likely be directed by the judge to turn over that ISO report before they testify. There's tons of case law on that. You're not going to be able to lawyer your way out of it. Abraham Lincoln or Clarence Darrow would not be able to get out of turning that over. If you came to me, I would tell you, turn it over because that's the basis for your raising fraud. Produce the report, put the claimant on the stand, cross-examine them. And the misrepresentation, again, it's not what's in the ISO report. It's not what's in that non-covert surveillance. It's their statement on the employee claim form. So essentially your cross-examination would be almost limited to, did you sign the employee claim form? Did you write this in there? Thanks, I'm going to sit down now. That's it, right? Example number two, the claimant says, I have no priors on my employee claim form, but we do have an ISO that shows multiple priors. We use it to subpoena the prior providers who provide the records, right? That's a very common thing for us to do. We find prior treatment, we subpoena those records. Now you could use maybe the records as the opportunity to raise fraud and keep the ISO in your back pocket and then use the ISO on rebuttal, okay? It should come in over an objection. You don't have to produce it. You can, again, introduce it during your rebuttal or cross-examination, all right? So again, you're thinking about how do I want to tee this up or set this up? And I want you to think about your audience there. Your first audience is the judge. And how can we present the most compelling case to that judge? And then, protect the record as best as possible so that we're ready to proceed with our appeal when the judge doesn't find that the claimant has committed fraud, because a lot of the times they don't, even when they should. All right, next, covert surveillance is a different animal. An employer may withhold video surveillance tapes and investigative reports until after the claimant testifies and receives the benefit of maximizing the effect of that evidence for cross-examination purposes. Those cases go all the way back to 2001. It's been extremely consistent over the last 25 years. So keep your powder dry. You never have to turn that over. Judges will still direct you to do it, right? Judges will say, turn over the reports before they testify, turn over the video, share it. Our answer is always no, never going to do that, right? All right. Best practices for covert. Covert surveillance can be costly. Our minimum that we're going to tell clients to do is 3 to 5 days of covert surveillance. It's going to cost thousands and thousands of dollars. I want you to be thinking about the value, exposure value of your case. You got a broken finger, pinky toe, or something like this. Is it worthwhile to go and spend all that money to go develop covert surveillance in a case like that? Probably not. So, use your best judgment. Now, that's not me telling you that we consider cost when we are fully and vigorously defending a case. We do not. We do not. When we make recommendations to clients for investigation, for surveillance, for looking into someone's history, for looking at their prior medicals, do not take the consideration of what is the budget for this into account. Who cares? Our duty, our professional duty, is to fully and vigorously and thoroughly defend our clients, regardless of cost. Okay. Now the client can come back and say, well, hey, we don't want to spend that money. That's their decision, but we should not be tempering the vigorous, aggressive defense of a case based on cost. That's simply not part of our duty to our client, right? At all. And in fact, the insurer is not allowed to do that either. The insurer is not allowed to say, well, we're not going to fully defend this case because it's going to be costly, right? They have a duty to defend contractually with their own insured, so they have to put that first. All right. I hope that's clear. Now, the other things to think about with covert surveillance is it strikes out a lot. There's going to be a lot of no observation days. Why? I see some really dumb surveillance, particularly in my cases. I showed up at claimant's house at 4:30 in the morning. I saw no activity for 4 hours and I left at 8:30 in the morning. I'm like, cool. They're stoned out of their gourd on oxycodone or whatever, Oxycontin. They're, drinking beer all night. Like they're probably rolling out of bed around noon, watching Judge Judy, cranking down some more Oxycontin and beers. Like we know what claimants are up to all day, right, guys? Like we know that they're not early risers and go-getters in general. Okay, let's be frank. So when I see stuff like that, I go, that's just a waste, right? But even with a aggressive investigator, you're going to see a lot of no observation days. Okay, that can be very problematic for us. Even a good investigator trying to do really good work and getting good video are going to be attacked or neutralized by opposing counsel. And they have essentially two methods of attack against us. One is the observation frequency attack, and the second one is the no observation attack, right? So observation frequency attack, probably the most frequent one. I want us to avoid that. And then the no observation attack and the inferences that they ask the judge to assume are something that we have to head off and neutralize as well. So we have a protocol here that we utilize that we've been talking about for more than a decade now and trying to encourage clients to adopt. And it is our duty as defense professionals to remind our clients of what our protocol is for obtaining meaningful surveillance and neutralizing the attacks of our adversaries. So let's understand the weaknesses of our covert surveillance. The first one is the observation frequency attack. And this is where our client's own investment in investigation works against our own client. So they put 4 or 5 days of surveillance on the claimant. The investigator gets out on the stand. They've only got one good observation day. They get on the stand. And the first question, opposing counsel says, well, how many days were you assigned to observe this claimant? I was assigned 5 days. Okay, and you only saw them on 1 day. And now they're planting this idea in front of the judge that the other 4 or 5 days, the other 4 days where there were no observations by this investigator, the claimant was in just writhing in agony, in pain, unable to do anything, or they were recouping from their terrible pain that they were in, et cetera, right? They'll also make the inference that the investigator is only selectively including the good observations and ignoring the bad ones. So this is what I call the observation frequency attack. It's probably one of the more frequent ones that we see. And it's very pernicious because it turns our investment in investigation essentially against us. And this is why clients say, well, is it worth it to put 5 days of surveillance on someone? We're only at 12 minutes of video. All right. Again, we need to be able to neutralize that. The second one is the no observation attack, which is asking speculative questions, typically of our investigator, to put a seed in the judge's mind, right? And those speculative questions are, well, you were assigned 4 or 5 days. You only saw them once or twice. Isn't it possible that all the other time you didn't see them, they were having, the day you saw them, they were having a good day, and all the other days was a bad day, and they were in extreme pain and totally disabled. And again, it makes our investigator either speculate or say things that they don't know. Typically, this attack is also premised on our own report, right? They've turned out, if there is a written report that demonstrates how long this investigation was, again, that gets turned against us. And then we get defeated with this good day, bad day nonsense. So those are the two frustrations that we have to be prepared to neutralize and overcome. So our protocol that we talk about with clients is layered observations, okay, meaning I want multiple investigators. I never want to see a report. Reports never help us. They only hurt us. I want us to initiate observations. Originally, the I stood for instigate, but I changed that to initiate because I thought that was like a less mean word, right? Because I know eventually this is going to fall into the wrong hands, okay? And then the last one is schedule intelligently. Like 4:30 in the morning to 8:30 in the morning, that's just the dumbest thing I've ever seen in my life. We know who these claimants are, okay? So let's walk through it. First one is layered investigators. I do not want the same investigator for more than one day. I don't even care if the investigator caught them and got great video. I don't care. They're fired. Put in the next investigator the next day. If the investigative vendor cannot accommodate this, they should be taking off our list of vendors. So if they say, well, we're in a rural location, we don't have a lot of people out there. Okay, you're off the list, right? We need people that have a bunch of people on their payroll so they can make sure that we get a different investigator. You'll see pushback from the vendors. They'll say things like, well, this investigator found this person and they know what he looks like, so let's use him again. I'm like, no, please don't do that. You're just increasing the opportunity for A, the investigator to get made, or B, for me to have to defend something in court that's going to be very difficult, which is multiple days of observations, what I'm trying to exclude. If the investigator does not find the claimant, does not record any video, what happens to their investigation video? Nothing. It goes into my file. I deep six it. I bury it somewhere in Practice Master. I never bring it up. It's like it never happened. So by doing this, we get to eliminate no observation days. Okay, very important for us. This neutralizes about 50% of the claimant's best attack, which is good days, bad days. Okay, which is extremely frustrating. Does this cost any more money than just doing the same investigator for 5 days? Absolutely not, right? Because the vendor's going to charge per day. They should have a different investigator each day. And that to me solves half the problem. Here's how I solve the second half of the problem. Omit the report. I don't want to see the report. I'm not interested in the report. You're only going to send me the video of days where you captured the claimant, you made observations. I don't care what the investigator wrote in that report. It's not interesting to me. I don't care about their opinions. I want to watch the video myself. It's very important that either the paraprofessional or the attorney watches the video themselves and takes a look at what did they capture, how useful is it. Written reports are going to be discoverable, right? I haven't found any case law that says that we can prevail on that argument. There's a lot of case law that says we don't have to turn it over, right? Because we can make the argument that says, hey, the best evidence here is the testimony of the investigator, and the parole evidence is going to be their video that they have obtained. But there's also a contrary case law that says the judge can order us to turn it over. And you'll find board panel decisions that say that, not appellate level decisions that say that. The legal team should evaluate the footage, not the investigator, and says what we should use and what we shouldn't. This also means our investigator, who by the way is getting paid $16 an hour and probably has a very low skill set, is not going to be confronted with a report and asked questions about that report that they're not going to specifically remember, right? So that's not the witness and not the testimony you want to defend on the stand. This, again, will help you neutralize the no observation attack that they will spring on us. All right, next thing, initiate observations. It is not useful to me to have the investigator say, I drove up in front of this dum-dum's house and sat there for 2 days. Useless, right? How do I even know the person's inside the house? Okay. Every investigator needs to get out of their van or truck, and they need to do something affirmatively to confirm that the claimant's actually at the location. Okay. The number one pretext that they can use, the best pretext, is deliver fake food to them. Just go up to their door, ring the doorbell and say, I'm here to deliver your DoorDash. And they say, is this for who lives here? Is this for you? Is this not for you? Right? That's an easy pretext. Okay. If the investigators are not getting out of their van, that's very useless to me. A no observation day could be turned into an observation day, and we figure out, hey, can we ring that doorbell and find out where they are? And there's lots of other pretexts they use. They use the lost dog pretext. They use the I'm trying to deliver a package pretext. I really don't care what it is, but they need to initiate some kind of contact and try to turn that no observation day into an actual observation day. Okay. I think that's really important. Another thing, that if we know that the claimant has a side business, right? We had a case here, I think we talked about it in CAPS a few months ago, about the claimant who also was working as a model and had a model page where you could book her to be a model. And we said, okay, investigator, book her to be a model and do like a shoot. And the shoot, I want the shoot for her, tell her that it's going to be like a sporting suit, and you're going to have her do all sorts of things and jump around and bounce a ball, do whatever we could do to try to initiate some kind of actual observation. Okay. The last thing is scheduling things intelligently. In other words, we're not just going to put 5 days in a row. Let's put days when we know they have an IME, they have a medical appointment, they've got an examination coming up, like something useful so that we maximize our observation. Now, these best practices will make sure that our investigator does not get cross-examined with their own report or some report that they're not going to remember facts from. It eliminates the good days, bad days things. And it puts us in the driver's seat, particularly when you get some good video and you're going to be able to strategize what you're going to present, what you're going to keep in your back pocket. And it reverses the problem that we have with good days, bad days. Now, if you're sitting out here and you're like, okay, Greg, this is a lot to remember. I usually, when I just tell clients I recommend surveillance, I just write to them, I recommend surveillance. I don't want to have to type this whole thing. Okay. Your job, though, as a legal professional, is to guide your clients and to make sure that the money that they're spending on these efforts, the investment that they're making in investigation is actually useful, right? So it's very important that we tell them about this protocol and we say, hey, please do this, follow these steps. Otherwise, they're going to go spend this money, get all this investigation, and it could actually worsen the defense position in this case, okay? So we want to help them maximize their investment. The second thing, be thoughtful about authenticating these witnesses. These investigators, you're going to need to put them on the stand. We had an issue with one of our vendors recently where the investigator, I said she didn't want to testify. I don't remember whose case it was. Maybe it's someone in this room. And she said, oh, I'm scared of going to court. I've never been in a court proceeding. Okay, what's our job now as professionals? Our job is to prepare this person for their first day of testimony. We should be reaching out to our investigators and saying, hey, this is what's going to happen. You're going to get sworn in. There's going to be another party there. Walk them through their testimony, right? This is not an IME, right? So we're allowed to prepare them for their testimony. Go through the questions you're going to actually ask them. Your direct should be very limited. It should be limited to how many days were you asked to observe the claimant? Their answer should only be 1 day. When you observed them, did you make a video of all your observations? Yes, I did. Did you edit, change, modify, or delete any part of the observation videos that you took? No, I did not. Okay, we play the whole video. Then you go, was that the whole video that you did? Yes, it was. Okay, thank you. No further questions. There's no opportunity there. There's no door open for opposing counsel to attack your witness or to ask or call for speculation. You've closed the door on all of their opportunities to attack your witness. Okay, so that's how that should be done. And that's our role. Prepare that witness to authenticate that video and get them off the stand as fast as humanly possible. Now, when we guide clients, I know this is a lot to remember. So there's now a macro inside of Practice Master. So when you're in a status update screen or you're doing a post-hearing report and you recommend surveillance, all you have to do is type LOIS-P, which stands for LOIS Protocol, / and hit enter. And it will put the whole protocol in there. It'll tell the client, okay, here's how we recommend you obtain surveillance. We recommend you follow our protocol, which is 1, layered observations, 2, omit the report, 3, initiate, and 4, schedule intelligently. And then if you want to be a superstar, okay, when you do this, say schedule intelligently, you might want to put an extra sentence in there like, hey, they have an IME coming up in 2 weeks. Let's get surveillance the day before, day of, day after, right? Like that would be super useful to tell them, or to initiate observation. Say, hey, they live in a neighborhood. Maybe you could pretend to deliver DoorDash and get them to come to the door. Give them a little more. You could add on to that, but you can use this macro and you could stick it in there. When am I recommending surveillance? It's usually in my pre-hearing or my post-hearings, right? Something happened and I'm like, let's follow up on it. Or, hey, this thing is coming up. Let's get this ready. Or just a regular status update. Medical milestones are coming in. Your IME report's coming up. Those are your opportunities to be recommending this, okay? Now, what's new? What's coming in surveillance right now? I'm defending a case today that came in with unmanned surveillance. Who here has got unmanned surveillance in any of their cases? Okay, James, I got a whole bunch of them. Okay, John's raised his hand. Great, okay. So we're defending cases with this now. Problematic to defend cases with unmanned surveillance. Authentication of the video is going to be the biggest problem, right? Some of the reports that I've seen come in with unmanned surveillance are like pretty cagey about if it actually is unmanned surveillance or not. The bottom of it will say something like this surveillance was obtained. The one I just read was said with watchful eye TL300. I'm like, that's pretty cool. The TL300. I Googled what the heck that was. I think they just made that term up. I don't think that actual piece of equipment exists. Who cares? Clearly what they did was they stuck a box, a fake something on a post outside the claimant's house. And it's really good for capturing their patterns, because every time there's movement in front of their house, the machine turns on, captures their movement, and we start to see what are the patterns of the claimant. Now, there could be admissibility and authentication issues, right? Because no one actually recorded this video. It was done in an unmanned way. I've only found one piece of case, or one piece of case law, the Cisco Corp case from 2021, in which unmanned surveillance was attempted to be relied on by the defense in that case. In that case, they never even got to the issue of whether it should be precluded or not. So there is no precedential case law that says you cannot rely on unmanned surveillance, right? So that to me is interesting. But I do think we're going to have authentication issues with unmanned surveillance, particularly when we're saying, okay, well, how do we know this was not edited, modified, changed, or deleted, right? Which is, again, one of the vectors of attack that opposing counsel is going to have against unmanned surveillance. So my advice to clients is, if you want to use it, that's great. And there's a couple of vendors up here that are utilizing it right now. That's fine. Use it to establish patterns of life. Use it to establish who else this claimant lives with. Use it to establish what times they're home, what times they're not home. That's all wonderful. I think we're going to have problems on the admissibility, particularly in your case in chief. If you're going to rely on unmanned surveillance for your, here's why I'm raising fraud, I have unmanned surveillance. I'm not going to say that, right? You're just going to say I have surveillance video. And then savvy adversaries can say, well, who are you bringing in to authenticate? And you go, haha, I'm going to bring in the watchful eye TL300. Good luck with that, right? Okay, you could try it. Okay, so I don't think it's going to be something that would be sustained. I don't know. I definitely think we should get to the forefront of trying that. But again, on rebuttal, I think it could come in, right? On rebuttal, particularly if it's got time and date stamps on it, you could potentially utilize it. You've observed them do all sorts of items. Maybe you've raised fraud based on other grounds. They come in, they testify, they say, I can't do this, I can't do that. You walk them through everything that you saw them do on unmanned surveillance, and then you use the unmanned surveillance on cross-examination. I think you might be able to defeat the objections to authentication of that parole evidence for that purpose. So again, I'm just trying to put ideas out there in people's minds as to how we could utilize this. It is quite effective. It is obviously a very efficient way of at least securing patterns and then observing the clue. All right, so some takeaways from today. First, I think we should keep the end in sight. We should raise fraud even more than we're raising it. I think it's a common thing that comes up in office hours where people will say, well, I got this, it's not so great, we're going to try to get some more. Use what you got, go with it. There's no bottom threshold for surveillance, and even if you're not successful, you can get more of it. Also, there's nothing that says once you've raised surveillance, you can't get more video afterwards, right? Or before the case is listed. There's no case law that says you can't do it. If you're lucky or you have a strong case for fraud, it's going to have a strategic impact on your case. You're going to foreclose their opportunity for future indemnity benefits if you get that lifetime ban, or at least you'll be able to get the benefits suspended all the way back, either to when the fraud was actually manifest or when you at least raised it in your case. So again, you want to raise it as early as you can. Some clients want us to be aggressive about raising fraud, right? Because it sends a message in the workplace. There's nothing worse for morale, when Tony drives up to the workplace and in his brand new Escalade, and everybody says, wow, nice Escalade, how'd you get it? He goes, you remember that fall off the dock that happened 2 weeks ago that nobody witnessed? That's how I got it. And everybody knows it's a fraud. I mean, that's a morale killer. Nobody wants to work around that. So some employers will say, let's raise it, just to put the message out there that, we are not tolerating this stuff. And also be mindful of your goal. Tactically, are you raising fraud so you can just build up some leverage so you'll have that opportunity to settle your case? And again, that's primarily what I think the value of raising fraud and being successful with it. And also, again, some of these things that we've talked about today, particularly the timing of the proofs, whether it's going to be your case in chief or we're going to use it on your cross-examination or rebuttal so that you can maybe avoid some of the admissibility issues that you might have, right? Those are all really good appeal issues. And what happens when cases get appealed on issues like that? They settle, right? And that's our goal, is to close these cases. All right, questions and answers. Questions. I'm going to go to the question panel. questions. All right, I see one in the back. Grab your box. Do it. Did someone throw a box to Cora back there? Go ahead, Brad.
Is the ISO actually sufficient?
Yes.
For fraud?
Yes. And this is something that we've picked up from defending NYSIF. NYSIF has a very interesting approach to using the ISO as its own, as a basis. So their approach, which I think is a great practice and something that we can deploy here, you have an ISO that conflicts with what's been told to the treating physicians in any one of your CMS 1500s or in the employee claim form. So you have an ISO that conflicts with it. You can use just the ISO by itself without any other evidence as your basis for raising fraud. Now, the downside to that, of course, is the judge, when you go to that proceeding and you say, set this down for testimony, the judge can say, turn over the ISO. Okay. So just to understand that it's going to come in at that point. I haven't found any case law that says once you've raised a fraud based on an ISO, you get to keep it in your back pocket and cross-examine the claimant like you can with covert surveillance that you've obtained through your own investigation. Okay. So it's going to come into the case. The fraud value, the surprise value is gone, but that is absolutely a basis. And what they do, which again, this is a practice that we should consider. I'm kind of studying to see the efficacy of what they're doing. Is they're actually making a proffer with an affidavit or an affirmation saying, this is the basis for my fraud argument or raising fraud. And why are they doing that? To avoid the frivolous controversy argument that's going to be raised by opposing counsel. Okay. So you need a box, but I see your hand. Let's go to Cora next. Let's go to Cora. Okay.
Two benefits to that is, number one, you're going to get HIPAAs when you provide the ISO. It's a lot easier to get the HIPAAs. And the second thing is, I always say, let them build the case against themselves. So once you provide that, you're actually asking them to help you get the records that you're actually going to use against them.
Great. And that is one of the biggest complaints. I'm not going to I'll use the word frustrations that is in our paralegal channel at any given day, right? HIPAA's rejected, don't get the HIPAA, no one's returning my HIPAAs, I can't get my records. So you use the ISO, you go to court, you raise fraud, and then you say, judge, direct them to execute HIPAAs for all of these providers that I've listed in this ISO and all of these insurance carriers, and the judge then directs them to do it, right? That's a great opportunity for us. And you're right, it makes them participate in our building up our own defense. I love that. Great point. Okay, Cora.
So what happens if you get good surveillance on one day, and then that surveillance report or the surveillance provided for that day has other videos from that same day of them like potentially doing something, maybe potentially doing stuff that's like, okay, but there's like one good video that's really good for fraud. For the purpose of like turning over evidence after the claimant testifies, do you have to produce all the surveillance on that day or only the surveillance that was good?
My advice is produce it all.
Okay.
Produce it all, because your crossing of your investigator should be, every time you observe this person, did you turn your camera on? Yes, I did. Okay, well, that's the answer we want from them. That's the instruction we give them. Every time you observe them, video them. Okay. And then we're going to make the decision as professionals whether we're going to use it or not. Because I mean, we've all watched, video where they come outside, they smoke a cigarette, they sit down, they pet the dog, they drink a beer, they go back and stuff. Like, this isn't great. Maybe you decide I'm going to deep six and I'm not going to use it at all. Okay. But I think once you're going to use any part of an observation day, I think you turn it all over, because otherwise it's going to weaken you if the adversary says, well, did you capture other video beyond what you just demonstrated to us? And the person says, yeah, I did. And they go, well, where's that? Well, we didn't think that was important. It was just him sitting in a rocking chair, writhing in agony. That's going to undermine our fraud argument, right? And so we should make that decision before we decide to use any part of the observation day. Is the whole on a holistic basis, is it going to help us or hurt us? Yeah. All right. James and then Joe. Could you pass that back to him, Jeremy?
Can you ask an investigator, like, I don't even know if this is kosher, but like, could you ask an investigator to take their covert surveillance and like submit it to the police? Because like in this specific example, our guy, cars keep pulling up to his house. He walks out, they exchange things. We can't see exactly what they're exchanging. And then he walks back inside, and we have tons of surveillance of him doing it, but none of it is conclusive enough. And
Okay,
like,
so this is common. Like we've got a lot of video of people being drug dealers, having affairs, doing all sorts of, doing illegal drugs on camera. Like we've got all of this stuff. My advice is let's win the comp case first before we get them incarcerated. Because remember, benefits are going to continue and you get them put in jail, all these other problems, that the benefits are going to continue until they're convicted. So my advice is we're here to defend a workers' comp case. That's our duty, not protect the public from this drug dealer. So unfortunately, my advice to you is let's use it for what we obtained it for. And then later on, if somebody else, wants to refer it to a fraud prosecutor and that fraud prosecutor wants to refer it to local police for prosecution, let them do whatever they're going to do. But I don't want us to get involved in that. We've gotten dragged into RICO cases. We've had FBI agents because of forged kited check situations, all sorts of criminal, crazy stuff that we've been involved in. We don't want to be involved in, and our clients don't want to spend money or those types of things. So even though, yes, it would be emotionally satisfying, no, we should not. Let's win the comp case first, and then, let's get them jammed up. All right, Joe.
it was just a small follow-up to Cora's comment. If the 1 day of investigation footage that we got was captured by one investigator, I think it's true we want to submit the whole thing, but sometimes you'll get an investigator that captures things in the morning and then someone else at night. If it's two different investigators, then it would be okay to bury the non-good surveillance versus the investigators' footage that captures them doing something. I get it. It all depends upon who took the footage on that day, I think.
100% agree. Yeah. Yeah. So I mean, we want to be as thoughtful as possible about maximizing the investment that we've made in this investigation. But also I think the danger that we could put our client into of hiding things that it's going to come out on cross. They only have one way of neutralizing our evaluators or investigators, which is this everything? And if the person says it isn't, now we have all sorts of proof problems and credibility issues, I think. We don't want to be in that situation. Okay, any other questions? Anyone from home? No home player questions? Okay, with that, I will close this presentation. I have to show you this. A view of this. Yeah, we have an email newsletter. Everybody knows about that. Christian's podcast. Don't forget about that. And course evaluation form. I need to demonstrate that. Okay. Thank you, everybody.